Hi, folks. We're going to go ahead and get started fashionably late, of course. But it'd be great if folks could take their seats. Welcome. I'm Joanne Camaford, and I direct the Human Rights in the U.S. project at the Columbia Law School Human Rights Institute, and I'm here with my colleague, Kate Kelly, who's a fellow with our project.
Welcome, everyone. Thank you for making it here on a rainy day. We knew there would be slight attrition. We're like, oh no, it's raining. So just a few logistics. You have in your light blue folders, you have materials list, you have info on all the panelists. So if we don't give a full bio, it's all in there. And then, of course, the most important thing is the CLE evaluation form. You must fill out the evaluation form at the end in order to receive CLE credit. So don't forget to turn that in. You also must sign in, which hopefully you've all done, but also sign out when you leave to get CLE credit. There will be breaks between all the sessions, but there will be, the beverages will be on the side, and feel free to get up. The bathrooms, if you go past registration and turn right, the bathrooms are just down there, and those are the only bathrooms on the floor. And if you need to take calls, there are some booths right in the hallway behind the second door. There are some soundproof booths. There are 3. So if you need to take a call or do a meeting or anything like that, those will be available all day for conference attendees. The other logistical thing is the Wi-Fi. There are Wi-Fi instruction cards on your tables if you need to connect. If it's not connecting, the first thing you need to do is go to a website you've never been to before. So I tried that and it wasn't working because I was trying, bbc.com or something, but you need to just put in a website that you've not been to before if it's not working, and then it should prompt you for the username and the password. And the last thing, really quickly, is there is a social media cheat sheet on every table. There should be a couple there. We do encourage folks to tweet and to post on Facebook, and hopefully if you can connect to the Wi-Fi, you'll be able to do that. So if you're looking at your phones, we'll just assume that you're tweeting some profound tweets throughout the day instead of checking your email. So go ahead and just keep abreast. The main hashtag is just Human Rights CLE. So keep tweeting with that throughout the day. And that's a good way to interact and have all your questions and insights that you gain throughout the day. So again, check in and out if you're getting CLE credit, and make sure to fill out the evaluation form and turn that in. And if you don't, you won't get CLE credit. We've been told. I'm just the messenger. So welcome and thank you. Yes. We'll remind you again, but just make sure to fill out that eval. Thank you so much.
It got very quiet. Good morning and welcome. I'm Joanne Camaford. I know many of you, but not all, and I'm glad to see new faces as well. And on behalf of the Columbia Law School's Human Rights Institute, it's really my pleasure to welcome you to today's Symposium, Racial Justice and Human Rights, Rights-Based Strategies for the Current Era. We're thrilled to gather for what is the Institute's 15th annual symposium on human rights in the United States, and together we'll embark on a day of learning and strategy sharing around efforts to hold the U.S. accountable to global human rights standards. We'll hear how an array of advocates and lawyers are using human rights to challenge all forms of discrimination and racism, and to resist the rollbacks and protections that are raining upon us daily. In 2014, the Institute hosted a day-long CLE program on the Convention on the Elimination of All Forms of Racial Discrimination, also known as CERD, the core international human rights treaty on race, and one which the US has ratified in 1994, and which we will discuss further today. The 2014 event occurred at a moment of US re-engagement with the international community, a time of human rights renewal in the United States. Today, we are in a very, very different place. In a country, as a country than we were then. We have a different presidential administration. We have a different Congress making key decisions that impact all of us. The national leadership today is focused on isolationism and has expressed a blatant and vocal disregard for human rights as a matter of policy. Over the past 2 years, we've seen laws and policies that are mired in racism and grounded in discrimination. Almost daily, we learn of new policies targeting communities of color. The current administration has rolled out travel bans and anti-sanctuary policies. They've increased surveillance and sought to limit voting rights and the right to protest, as well as to remove regulations put in place to protect the environment, fair housing, all of which have a profound negative impact on Black and brown communities in particular. The most recent exposure of policies that separate immigrant children from their families is one of the most flagrant and emblematic of the ways that identity-based harms are impacting communities in the United States. And the outrage is palpable, right? Today is actually a national day of protest against that action, and there's a nearby action after this event in Foley Square at 5 if people want to go to that. We'll have more details later. But it's also true and important to remember that many of the challenges that we face today are not, in fact, new. Discrimination and marginalization of communities of color did not begin with our last presidential election. These problems permeate our history and emerge from structural and systemic factors embedded in our laws and institutions. To address them, we need policy approaches calibrated to dismantle causes of discrimination and inequality. And while there have always been impediments to realizing human rights in the United States, we can't downplay the new threats we're seeing to institutions that we have often looked to protect the rule of law and uphold democracy. And the rollback in civil and human rights really provide a new urgency to our efforts to combat racial injustice. The theme we are focusing on today, advancing racial justice, is one of the most pressing of our time. And the human rights framework, which includes core principles of equality and non-discrimination and calls for decision-making that centers the experience of those most impacted, can provide vital tools for change. Indeed, it was challenging discrimination in the United States that first brought US groups to the United Nations. In 1947, the NAACP made an appeal to the world, going to the UN to accuse the US of human rights violations based on discrimination against African Americans. And challenging discrimination has been a key theme of human rights advocacy ever since. When the US ratified the CERD, the Convention on the Elimination of Racial Discrimination, it committed to undergo periodic reviews of its human rights record and opened the door to raise these concerns periodically at the global level. Of course, US advocates stepped in, and many people in the room were part of the early engagement at the UN treaty bodies. But human rights advocates have also raised these concerns in cases before the Inter-American Commission, our regional human rights body. And UN and Inter-American experts have repeatedly made recommendations to the US on how to make improvements. Since its inception 20 years ago, the Columbia Law School Human Rights Institute has been privileged to work in partnerships with lawyers and social justice advocates to cultivate implementation of human rights through a range of advocacy initiatives to address inequality and promote racial, gender, and economic justice. And we have worked to build the capacity of lawyers to develop strategies to advance human rights. And the breadth of strategies that our partners, many of you in the room engage in, are really remarkable. They've led to the inclusion of human rights in Supreme Court decisions, including on juvenile life without parole. They've resulted in state and local policy that expand women's rights and improve access to justice. And increasingly, human rights are part of movement-building efforts to secure housing as a human right, to ensure access to sanitation, to fight against encroachment of pipelines on indigenous communities, as well as to promote workers' rights, among many other issues. So it's with this background that we gather today to explore the relevance of human rights principles and strategies as tools to challenge all forms of discrimination. We're also here to discuss the many challenges that we face in these efforts and ways to overcome them. Our sessions today will focus on many different aspects of and tactics for advancing racial justice nationally and locally. We'll explore opportunities offered by integrating human rights into local policy to foster access to water and other basic services. We'll examine strategies to bring human rights norms into litigation regarding a range of economic and social rights. And we'll look at how advocates are engaging with international and regional mechanisms to bring greater awareness to local concerns, particularly the use of force in Black and brown communities. And we'll explore how basic human rights principles like dignity, equality, and non-discrimination are influencing domestic advocacy related to economic justice. We'll talk about how a rights-based approach can complement efforts to secure civil and political rights like voting and education, as well as how advocates are leveraging United Nations mechanisms to shed light on the racial dimensions of poverty in the United States. To help us achieve our goals for today, we're extremely privileged to have a remarkable group of speakers from across the United States, including human rights advocates, academics, and federal and local government representatives. And because it's a CLE, we will focus in particular on the role of lawyers, in particular in advancing human rights. Among the officials joining us to share their unique insights are Chairwoman Catherine Lehman of the U.S. Civil Rights Commission and Robin Toma from the LA County Human Relations Commission. And we'll also hear from a broad array of advocacy perspectives. We'll hear from international human rights organizations like Human Rights Watch about how their advocacy is pivoting in the face of current threats, and from local groups like the Michigan Welfare Rights Organization and the Community Justice Project about efforts to implement basic economic and social rights protections. We thank all of the speakers and moderators for their participation and for generously sharing their knowledge and insights with us today. Columbia's Human Rights Institute is really proud to sponsor today's event. As part of our project focusing on the human rights in the United States, we coordinate the Bringing Human Rights Home Lawyers Network, which connects at this point over 900 lawyers from domestic civil rights, human rights, and legal services communities to share information and develop strategies for integrating human rights to advance social justice. If you are not already a member, please consider signing up today, and you can do so at the information table outside. And it's really my hope that today marks the beginning of a collective conversation and enhances collaboration, and we'll use our network as a space to facilitate next steps conversations, including in a summer meeting, which you'll hear about later. The Institute is really privileged to have a wonderful group of co-sponsors for today's program: the ACLU, the Center for Constitutional Rights, the Center for Reproductive Rights, Latino Justice PearlDeaf, the UPenn Transnational Legal Clinic, and the U.S. Human Rights Network. We're grateful to our co-sponsors, and I would like also to thank in particular Jamil Dakwar, Risa Kaufman, Natasha Bannon, Sarah Pauletti, and my colleague Kate Kelly for their partnership in shaping today's program, as well as the Human Rights Institute's Managing Director, Maya Al-Khateb Chami, and Columbia's Gerline Paul, and the team of volunteers here today who got together all the materials that we see before us. I also want to recognize as well the generosity of Cleary Gottlieb for hosting the symposium in this lovely space. Cleary has a strong commitment to social justice, engaging in human rights advocacy globally, including in the United States. And I particularly want to acknowledge Jennifer Croman, Catherine Hughes, Akila Brown, and Eliza Worley for their time and energy. As a former Cleary associate, this is where I first worked after law school, I feel a particular gratitude and thanks as much of my early legal training happened here. And lastly, and most importantly, thank you to all the remarkable advocates who are working to promote human rights in the United States, for the innovative work you're doing, for inspiring today's discussion, and for leading the work in the years ahead. We are counting on you, so thanks. And now we're going to actually start with today's program. So it's my pleasure to introduce our opening speaker, Todd Cox, the Director of Policy at the NAACP Legal Defense and Education Fund. I'm thrilled to have Todd with us today because he brings to our discussion a unique breadth of experience fighting for civil and human rights. Todd has worked as a public defender in the District of Columbia and at the Department of Justice. He's also worked on policy advocacy at the Lawyers Committee and the Center for American Progress, where his work has spanned voting rights and redistricting and a range of criminal justice issues, including ending mass incarceration and criminal justice system reform. He has also fought to ensure that individuals with criminal records are afforded a second chance. I first came to know Todd during his tenure as the director of the Office of Communications and Legislative Affairs at the U.S. Equal Employment Opportunity Commission under President Obama. In that role, Todd worked on an array of issues, including reforming the EEOC's policy on the use of criminal records in employment to improve individuals' chances of employment after incarceration. At the EEOC, Todd also contributed to U.S. government engagement with the United Nations. He traveled to Geneva, serving on the U.S. delegation as part of the U.S. Review under the Universal Periodic Review process, and he joined many, many civil society consultations. He also helped to strengthen the focus of his agency, the EEOC, and many of their state and local partners on the potential for human rights to strengthen their work. And it makes sense that Todd was attuned to these issues and a really strong ally, because as prior to his appointment to the EEOC, he was a program officer and acting deputy director of the Human Rights Unit at the Ford Foundation, where he advanced the equal rights of racial and ethnic minorities and indigenous peoples in the United States and Latin America. So Todd has much experience and insight to contribute based on his past experience alone. But in Todd's current role at the NAACP LDEF, he has a wide portfolio. He's monitoring and challenging federal and judicial executive nominees to maintain the integrity of our federal branches. He's also engaging in advocacy related to criminal justice, voting, education, and many other issues to foster equality under the law and challenge discrimination. So the Human Rights Institute and today's co-sponsors are really grateful to have Todd with us to kick off today's program. So Todd, thank you for all you do, and I'll turn it now over to you.
Good morning. And thank you, Joanne, for that introduction. I really am very privileged and grateful for the opportunity to speak here and be here and to reflect a little bit on racial justice in the context of this current administration. I'm going to give my reflections, and they're just examples. I think that they are, in some ways, examples that can be applied across a number of areas, not just racial justice. But I'm going to really focus in on the policy and civil rights law enforcement lenses and examples within the context of voting rights, educational equity, and criminal justice and policing reform, and then offer some insights or share some thoughts about a path forward. I think, sort of to begin with, I think it's impossible to discuss racial justice in the United States under this particular administration, and I realize we're being recorded, so I'm going to be as direct and yet careful as I can in terms of talking about this, without appreciating the context within which all of this is happening. At the federal level, at least, and I think it's permeating across a number of areas beyond the federal level. All of this is occurring. All of the civil rights enforcement, all of the human rights enforcement with regard to racial justice is happening in the context of what a lot of us are calling the new abnormal. Joanne is exactly right. We've seen this before, but this is there's a particular angle that this is all taking, right? We have, it's a situation in a context in which in which advisors to the president, a number of them, give voice to white nationalism, misogyny, xenophobia, anti-Muslim sentiments, nativism, and these are intentional. And they're making policy pursuant to some of these thoughts and issues that they're giving rise to. We have a Department of Justice, the agency that I think becomes the focus or the hub for our civil rights enforcement in this country across the board, being led by Jeff Sessions, who rather unapologetically is openly hostile to civil rights enforcement in this country. We have judicial nominees who have records in their legal practice that reflect a hostility towards civil and human rights. And we actually even have two judicial nominees that can't seem to ratify or endorse the holding of Brown versus Board of Education. None of this is normal. And it's not that this particular cast on what we're seeing, we have not necessarily seen in exactly the same way. And so, with that frame, I'd like to sort of talk about the three areas I mentioned. And I'd like to start with voting rights. So the story of voting rights, actually, in this administration, and when I say voting rights, I don't just mean affirmative voting rights, I mean voter suppression, began actually in the current era 4 years ago with the case called Shelby versus Holder. Many of you know it. It's a 2013 Supreme Court decision that severely weakened the Voting Rights Act and allowed jurisdictions with a history of voting discrimination to no longer have to submit for preclearance any voting changes. Before Shelby, jurisdictions like most of the South, some counties in New York had to submit, and some other parts of the country, submit voting changes to either the Department of Justice for review or district court in the District of Columbia for review. Shelby versus Holder took that away, and in so doing, it opened the floodgates for numerous states and local jurisdictions such as Alabama, Texas, and North Carolina to impose new discriminatory voting restrictions, such as restrictive voter identification requirements that would not have been allowed before the case. With the Weakened Voting Rights Act, 14 states, including those previously covered by Section 5, imposed these kinds of restrictions. And those changes have real consequences, or had real consequences in elections, weakening turnout in many states like North Carolina. The efforts to curtail voting rights intensified after the election, as both state and federal level actors worked to undermine democracy. And in fact, since 2013, there have been at least 10 federal courts that have found states to have intentionally discriminated against African Americans and other voters of color. These include cases from Texas, Louisiana, Wisconsin, and North Carolina, including the Fourth Circuit's 2016 finding that North Carolina's restrictive voting practices targeted African Americans with almost surgical precision. At the federal level, all this is happening, as I said before, in the context of the new abnormal. And it's not surprising that we have a Sessions Department of Justice that's failed to fulfill its mission to protect our voting rights, and in fact have sort of taken the opposite tack, backing up the state of Ohio in the Supreme Court as it pushes forward a purge program under the NVRA that punishes folks for not voting, in its opinion, often enough, and therefore it seeks to purge them. They flip sides in our attack against our lawsuit against Texas, challenging its voter ID law, saying that no longer did DOJ see that as an intentional discriminatory act. Never mind the fact that subsequently courts repudiated that view and found it was intentionally discriminatory. Since the election, we have a president that has, despite all of these examples of voter suppression, ignored those and claimed that many illegal voters, many voters from certain neighborhoods were bussed in to vote against him, denying him the popular vote, never mind the fact they actually won the election. All of that, I think, set the groundwork for him calling for an investigation of all of this, and it led to the creation of a Voter Integrity Commission. We called it the not Voter Integrity Commission, Voter Suppression Commission, led by Vice President Pence and Secretary of State Kobach from Kansas, who also has a spotty record of voter suppression. Well, not spotty, it's actually a record of voter suppression. And so May 2017, this commission was impaneled. And, again, context is very important. So we have this panel. The data that's enacted, it's put out there and impaneled. We have the Department of Justice sending out letters to states saying, what is your voter record system? Tell us how you are going about, I don't think they use the word purging, how are you going about making sure that your voter lists have integrity? Now, when I was at DOJ, we sent letters out saying, show us how your voter systems are operating in a way that don't exclude people, that you're actually complying with the NVRA. This letter was slightly different, and it caught a lot of people, caught a lot of attention because, while the commission said we're just investigating, we're trying to figure out if there's actually problems with our voter system, this seemed to indicate some, dare I say, collusion between the Department of Justice and this commission, and it fed, I think, an important narrative, which we think was true, that this commission was designed to manufacture evidence of voter discrimination or sort of voter lack of integrity or voter error in order to justify federal laws, state laws, and other kinds of policies that would suppress African American and Latino votes in particular. Now, why is this a particular concern, having Jeff Sessions send out these letters? Well, because as U.S. Attorney, he brought a lawsuit against our clients under trumped up, excuse the pun, trumped up voter fraud allegations. Now, none of that was proven to be true. The district court threw it out, but the damage was done. There was already a sense amongst all the voters in Alabama or all the voters, but certainly voters in Perry County, where he targeted that was no longer worth voting, and that kind of damage lasted very long. And so we looked at what happened with DOJ. We looked at this commission. We looked at the fact that Jeff Sessions was involved as an indicator of where actually this administration was going to be going with regard to voter suppression and with regard to voting rights. And so we joined other organizations in separate lawsuits challenging this commission. And our lawsuit in particular challenged President Trump directly, and it was brought along racial justice lines. Other organizations, quite appropriately, challenged the process, challenged the fact that this commission was impaneled in a way that was in violation of federal law. We said, you're impaneling this with the intent to discriminate against African Americans and Latino voters. And I think down the line we'll have a conversation about how direct I think how you really need to be direct about what we're seeing in this country with regard to racial justice and be willing to actually articulate it. We saw the fact that he had targeted in his rhetoric that, and Kovach too, sort of these trumped up ideas of voter fraud. We saw also that they were particularly aligning that with African Americans and Latino voters. And we also know historically that voter suppression and language like that was actually used to suppress African American voters' votes many decades ago. We put all that together and decided that that's really was the intent behind this. Well, fortunately, given the pressure, they decided to stop this panel and to perhaps even go sub rosa with their suppression tactics. They still bring up this idea of vote fraud, but the commission itself is no longer in existence. But I think we obviously are going to stay vigilant and make sure that there won't be another manifestation of this kind of attempt to collect voter information, which this panel tried to do, and to suppress minority votes. In the area of education, we see similar activity. As this year, we celebrate obviously another anniversary of Brown. We just celebrated it a few months ago, and we see that obviously discrimination and inequities along racial lines still exist, still permeate our education system. For example, we had a case in Gardendale, Alabama, where it was an old desegregation cases that sometimes people ignore, think are no longer valid or viable or don't matter anymore. Well, this was a case that was moving along. They decided in this case, in this county, to create a brand new, high-tech, state-of-the-art high school. Well, the white parents, the white individuals in this county said, you know what, we want that high school ourselves, so we want to actually break off from the county. And they went to the court and said, you know what, we want our own school district, and just that school district happens to be around the state-of-the-art high school. Fortunately for us, the 11th Circuit said, no, that's would actually foster discrimination, and we're not going to let you do that. I raise that as an example of the fact that even as we start closing out our old desegregation cases, we still have evidence of intentional discrimination, evidence of jurisdictions continually wanting to exclude African Americans from educational opportunities, and examples of jurisdictions trying to break off the white population in those jurisdictions, trying to break off from the African American student body. We have examples even from this administration itself in its own Office of Civil Rights, where there's racial disparities in student achievement, school resources, school discipline, and the like. These cases obviously demonstrate the need for robust enforcement of our civil rights in the education context and Title VI. Unfortunately, under the leadership of Secretary of Education Betsy DeVos, and I mentioned Attorney General Sessions, he's someone who's overtly hostile to civil rights, right? But we have other examples of nominees in this administration of folks who just don't seem to understand the laws that they're required to enforce. And I don't say that in any kind of to suggest that their behavior is benign. I don't think they're benign, but I do think it's a danger that we have folks in this administration. It reflects a lack of appreciation and respect for civil rights. We have someone like Betsy DeVos, Ben Carson, in place in these agencies, and in this particular agency, we see someone who is fostering rollbacks along the lines of what we discussed before. OCR, the Office of Civil Rights, is now processing complaints in a manner without really looking at any kind of systemic educational violations, saying that we're no longer going to even have that in our manual to advise the folks who are doing the investigations. They're now allowed, for example, to dismiss complaints that they say are unreasonably burdensome on OCR. If you have more than one complaint, for example, from a jurisdiction, which I think in some ways is the example of a systemic problem, that means, well, actually, we'll just do one and that's good enough. And these are intentional things. They've set out to remove this idea across the federal government of systemic civil rights law enforcement. This is just one example. In the wake of the mass shootings in Parkland, that tragedy, they used that opportunity to set up a commission with the intent to roll back our school discipline guidance the school discipline guidance put forward by the Obama administration, which was designed to really lift up the idea that you can be discriminatory in how you apply school discipline. There's statistics that show school discipline is meted out in a way that is discriminatory towards African American and Latino voters, education students. And the administration, both the Department of Education and the Department of Justice, put out guidance, just guidance, interpreting what the law already was under Title VI, saying that this could be done discriminatorily. Well, they'd already signaled in this administration they were going to roll it back. They used the Parkland shootings to sort of make a tortured link, which others had too, unfortunately, between having these school discipline guidance that ameliorates discrimination and the violence in schools. And they've set this commission up. We don't oppose seeking ways to make schools safe. We think that having a good, robust enforcement of civil rights laws is actually the way to do it. Instead, they are continuing down the path of rolling back their Title VI enforcement, rolling back the school discipline guidance, and wanting to really harden schools, fostering policies that would arm teachers, arm officials. And obviously, well, not obviously, but we oppose that. We think that that's a mistake. We don't think that makes schools any safer. And in fact, given the data we know regarding implicit bias or explicit bias, we think that puts African American students in particular in danger. So we've opposed that. We made it very clear we oppose it, and we're waiting and seeing exactly what they're going to do with regard to school guidance. Discipline guidance. We're hopeful that no news is good news to some degree, but we're not optimistic that we're not going to have to take other kinds of measures to make sure that that's not rolled back. And finally, I'm going to talk about criminal justice. And in the context of criminal justice, I'm going to talk about really policing reform and not really go into a lot of detail, but to give you the highlights about how this administration is rolling back efforts there to reform our criminal justice system. We're all too familiar with the crisis in policing in this country, with the almost seemingly unending examples of violence perpetrated upon communities of color, in particular by the police. And there's obviously this disconnect between communities of color, vulnerable communities, including people with disabilities, and the police. Unfortunately, again, I keep using the word unfortunately a lot, we now have an attorney general that and an administration that's promoting a one-sided law and order rhetoric. Right? We had an administration prior to this that over time began to put policies in place that ameliorated a lot of the policies or a lot of the practices that led to mass incarceration, that led to over-policing, that led to a police culture that really disproportionately targeted people of color in communities. This administration is trying to reverse that and go backwards. And when I say law and order, I don't want to imply that we don't favor enforcing the laws. We, however, in favor enforcing all of the laws, civil and human rights laws. And we believe you can do both without discriminating. You can do that as well as keep communities safe without discriminating against African Americans and Latinos. This administration, however, doesn't really want to focus on that. He's shown hostility to consent decrees, and consent decrees being a useful, critical tool for civil rights enforcement, but particularly a tool for enforcing and helping police communities have and achieve policing units and police departments that actually work well in communities and work well with communities of color. He's turned his back on that. A good example of that is what happened in Baltimore. Consent decree was negotiated in good faith with the last administration. On the heel of the very day before they were to go and get that consent decree approved, the Department of Justice sent a letter, the political sent a letter saying, you know what, we're not so sure we're going to go forward with this. Can we please delay it? Fortunately, the judge said, you're crazy. You actually have negotiated this consent decree and we're actually going forward. He didn't use the word crazy. We're going to go forward with it today and we're going to actually approve it. But I think it was a signal that this administration really we're willing to really cross even reasonable lines in court to say, we're not only going to flip sides with regard to the Texas photo ID case, we're going to actually on a consent decree, on an agreement that we actually agreed to comply with, seek to delay and seek to undermine. We, as LDF and others, sought to intervene because at that point, that was a signal to us that we needed to actually, get involved. The court said, "Hold off. We're gonna hold off on your intervention motion to see if actually Jeff Sessions goes forward with this in good faith." And so far, we're continuing our efforts there to make sure that happens. The last thing I'll say about the criminal justice area is that they've also rolled back these so-called smart on crime initiatives that were put in place in the last administration. Those initiatives were designed to basically ease the charging process that led to overly harsh sentences, led to the application of mandatory minimum sentences that really led to mass incarceration, the disruption and destruction of communities of color across the country. Jeff Sessions, of course, has flipped that and is going actually the opposite direction. Not only removing those initiatives, but actually criminalizing certain immigration violations and offenses that normally wouldn't be criminalized. So he's actually opening the floodgates to our prisons once again. Now, I realize all that sounds depressing. It sounds like there's really no hope, and I don't want to say that's the case because I don't believe that's the case. Actually, I'm actually more optimistic than that. But I think if you're going to chart a path forward, which is what I want to talk about now, we need to start by being open and honest about what we're seeing, and actually embracing what I described as the new abnormal. What that means is not treating this administration like any other. And it's not a partisan thing that I'm saying, but really understanding and really appreciating what we're actually seeing coming from this administration. Obviously, as I said before, overt, open hostility towards civil and human rights, and this idea that reforms in these areas are not going to be forthcoming. We must recognize also that the old playbooks that we used, that we had in place, may not be sufficient, may not work at all, and we need to develop new strategies and be willing to do that. I think a good example of that is how some of us behaved during the transition. I think folks decided, well, let me just pull the book off the shelf for how we did the Clinton transition or the Bush transition, and some of us, like me, said, well, I don't think it's going to be a transition like that. Given how this election went and given what has actually openly been said, I think we need new strategies. And those strategies are in being developed, but I think the willingness to understand that we need them is critical, because the normalization of all of this is what's going to, frankly, allow us not, what's going to maybe jeopardize our ability to survive this as a movement. So for on LDF's part, we've been very clear about where we are, the environment that we're in, and it's manifested itself in a few ways that I hope maybe you will find helpful. It started by not treating this as something even close to being a normal type of transition, as I mentioned before, or even any kind of normal kind of administration. And so we've been very clear about and circumspect about suggesting that we want to have the grand meeting, the meeting with officials to work on issues. And because I think if you have officials already telling you up front that, frankly, we don't value your stakeholders or groups, you have to be very careful about how you approach them, because you don't want to normalize their behavior or normalize what they're saying. So when we do meet with them, we make sure it's after a long period of time. We made it very clear what we think about you. So we're not meeting with you with any kind of sense that you're going to, in good faith, Jeff Sessions, actually operate in a way that would benefit our stakeholders. We're actually meeting with you to alert you to the fact that we expect, for example, you not to tell us when we land in Houston that you flip sides, but you give us common courtesy to let us know before we get on the airplane that you've done that. We want to flag for them that, in the case of perhaps Secretary DeVos, that if you roll back anything on school discipline, we will see that as an attack on Brown. Just giving you a heads up. And you can only imagine, if we think you're attacking Brown, what that means we think about you, right? That perhaps we think that you prefer Plessy, that you perhaps prefer an environment where schools, the Gardendale situation would have gone the other way. I'm not saying that you can possibly shame these individuals, but what I'm saying is that you're signaling for them and giving them perhaps a moment of pause before they actually take action. And that moment of pause is just another delay in rolling back something that we really think is critical to have. The other thing I will say is that we need to be more intentional and aggressive in making sure we coordinate across all of our sectors and groups. That means sharing information in real time. I know we're all part of 1 million listservs. I personally think I'm now part of 100 listservs, simply because I need to be connected with every segment, every community that's under attack. I may not be able to weigh in on everything, but I'm weighing in a lot more, I think, now than I did first time I was at LDF, simply because we need that kind of unity across all of our sectors. And similarly, I think we need to be more intentional about being helpful and working across silos. And the reason that is even before this administration, none of our communities existed in silos. And so the example I'll give you is that many at LDF, all of us, work on policing reform. We worked on defending or advocating against behavior, unwarranted violence against African American men, unwarranted violations against the rights of African American community members. Well, some of those community members, some of the names that we always talk about are people with disabilities. And I think we need to be more intentional about inviting the communities who represent the people with disabilities into the criminal justice space. We in the criminal justice space need to be more intentional about working with those communities as well, because those individuals didn't live in silos. The police were interacting with them based on the fact of perhaps their ignorance on dealing with folks with disabilities, but also because they're being targeted because they're Black men. But those kinds of intersections are sort of intersections we need to sort of fully appreciate and work on as advocates as well. I think LDF, this is the other point I want to make, is committed to being its own private DOJ, unfortunately. And that's sort of an umbrella for a lot of things, our own private Department of Education, our own private Department of whatever. I think that's not an easy decision to make, right? I think we're used to going to an attorney general and saying, look, we want to work with you on bringing a lawsuit together. Well, now we have to go to the attorney general, and he perhaps is the opposing counsel, because now we're suing Ben Carson over his rollback on the affirmatively furthering fair housing reg. We're suing Ben Carson over the Section 8 rule. We're potentially going to sue Betsy DeVos over her failure we have sued her, over failure to disclose certain information that we need for our advocacy. We're suing the president. So we're having to take on the mantle of being our own civil rights law enforcement organization, and we're not the only ones. A lot of organizations in this room are doing the very same thing, but that's a little bit different, and that's an extra burden and responsibility and cost to our organizations. We're now being more intentional, I think, about pivoting to Congress. I think we're looking at an administration that is openly hostile to many of the issues we want to work on. So we have to pivot to Congress. And that pivot, I realize some people will say, pivot to Congress, I think has a different gloss on it as well. When you walk into Congress now, I walk in with the same lens that I have with the administration, saying this is not normal. So when we're walking in and telling you need to exercise your oversight and budgetary responsibilities, we're telling you that because if you don't, the cost on folks that I represent really could be a matter of life and death. It's just that serious. And I think our accountability in terms of holding Congress accountable has to be at that level as well. So the pivot is the pivot, but it's an aggressive pivot, both in terms of requiring them to step up in an aggressive way and behave in a way that perhaps they're not used to interacting with an administration, dealing with administrations like this, but also I think an aggressive, intentional way of thinking about how we have to hold them accountable to make sure they go forward with this. I think that we need to make sure that the words they use in response to the Charlotte's tragedy, the school shootings, they actually live those words in terms of actually the policies that they're promoting. I think we need to still have an affirmative agenda. I know it's impossible to think of even doing that, but when I was at Ford and when I was at LDF the first time, thousands of years ago, we were still under attack. Affirmative action was under attack, education was under attack, everything was under attack, and we decided that we needed to fund affirmative strategies as well, not necessarily only because we thought we could actually win, but because it also put the opponents on their heels, making them respond, both from a policy standpoint, from a litigation standpoint. So affirmative strategies are critical, and I really want to lift that up right behind the defensive strategies, even if the affirmative strategy is the defensive strategy of suing the administration. That's something that's moving the ball forward, and it's requiring them to expend resources to fight you. And I think we've seen some, I won't say success, but I think we've seen some in the context certainly of this Voter Integrity Commission, we've seen some success in them saying, you know what, fine, and we won't do this anymore. And quite frankly, for some reason, they don't always expect it. They don't like being called out in the press. They don't like being exposed. I don't know why they would not think that would happen. But with regard to the Voter Integrity Commission in particular, they tried to vilify us. They were horrified that we were calling them racist. I don't know why you would be horrified by that. But so I do think there's some value in really taking the fight to them. And I would also say that it's critical, and I'm not putting these in any particular order, that we make sure we're pivoting and continuing to elevate state and local organizations. And the national organizations that a lot of us represent need to be held accountable for truly connecting with those communities. LDF has made a big investment, a big decision, has decided probably over the years to sort of return to our roots, to return to organizing. We're partnering with organizers on the ground, having organizers on staff, so that we're really able to connect in an authentic way with folks on the ground. Not just so that they can help us at our national level. That's not the point. But for example, with our policing reform campaign, we're actually in communities trying to be responsive to reform policing policies on the ground. And I think that that moving sort of affirmative strategies on the ground is an important aspect to not combating this administration, but actually achieving goals of protecting and securing people's civil and human rights. And I would also, the last three things, sorry. I think that there are two areas that I think, we all need to be, I think, cognizant of. And I would say these sort of have been seen as niche areas, areas that maybe not everyone wants to focus on. Judicial nominations. I know that based on my own experience working on this, not everyone works on them, works on these issues. But let me just lift up the need for the human rights community in particular to participate. I know everyone's overwhelmed, but to add their voice, add the ground game to it, because these folks are lifetime appointees. They're young, younger than me, and I'm 50. And these are folks who are going to be making decisions on civil and human rights for generations. And we may not be able to stop all of them, but we can stop some of them. And I think the more of us who are engaged, the more we can engage folks on the ground about the importance of this, about the importance of holding members of Congress accountable for approving judicial nominees that have hostilities towards our community members, the better off we will be. The other area that I think is also seen as niche and maybe not as interesting or as can seem a little Byzantine is the budget process. I can't tell you how important that is, particularly now where we can't seem to move anything in Congress that's going to help us. Well, the budget process is about the few areas where our allies have to negotiate with the other side and get something. So, for example, there's language in the budget that took care of. Some of you may have heard about the labor rule rollback that would have allowed companies to take people's tips. That was taken care of in the budget process. They basically did not allow labor to do that. Now that was probably a tough negotiation, but ultimately, if you're talking about passing a budget that's going to fund the military versus not doing anything at all, they conceded that. Same with OCR, Office of Civil Rights. We were very concerned that Betsy DeVos, because she was going to do it, was going to reorganize OCR on the ground. They were going to do all kinds of horrible things. There's language now in the authorization that says, you know what, you can't do that. And if you're thinking about doing it, you have to come to Congress first. Again, that's sort of intuitive, but it's not necessarily assumed. So I want to urge everyone to sort of engage in whatever way you can in the budget process. Funders, I don't know if there are any funders in the room. I think that, and all of you will be happy to hear this, what I'm going to say. We need to be funding and thinking about this for the long haul. That means capacity building money. That means project support, critical. But it also means thinking about all of this, not just in terms of a short game, but the long game. And that requires resources. To be the new Department of Justice requires a lot of money because that's not what we had planned on doing. So I think all the folks in this room are going to be having to step up and do that, and it's going to require resources. So I think funders, I certainly felt that when I was at Ford, that we didn't do enough to support general support. I know everyone feels that way here, but we need to be more strategic. Funders need to be more strategic about what's actually happening in the real world with regard to these communities. I think the U.S. human rights treaty process that Joanne mentioned is critical. Do I think you can shame this administration? No. Do I think, though, that the audience for participating and making them participate and making them engage with you is this administration? No. It's our stakeholders, it's the world, it's the larger community that we all serve. And I think as someone who worked at EEOC, I think we had an administration, obviously, that was more responsive. But quite frankly, no one in the government wants to have to, I'm being recorded here, but I think everyone in the government feels that they're doing a good job. They feel they're doing the right thing. And it's not that they don't feel they need to be educated, but this is anything that distracts them from exactly their strategic plan is something that they are reluctant to do. And by having Joanne, others step up to the State Department and say, you know what, we need you all. We want to meet with you all. We want to talk about what you're going to do about CERD. What you're going to do about all of these treaty obligations, and frankly, forcing the State Department to convene folks across all of these agencies. Frankly, agencies that would never have sat down together to talk about these issues. That was very important. And I think that, again, you're not going to shame this administration, but even that process alone would be helpful. These are career people who are going to be sitting in the room, mostly. Having them talk to each other, having labor know they need to actually include the EEOC on a regular basis in the conversations about employment, because, employment was in the name. That was important for this administration, for the last administration. I think it would be important even for this this administration as well. So I think that engagement is critical. So I'll end by saying this. I think there's good news in all this. I think that the experience and that we're having right now is unearthing hostilities and ignorance and dangers that were frankly deeply rooted in this country, but maybe went under the radar, particularly since we had 8 years of what we thought was, a fantastic, policy run. I think we now also know, or people now have a sense that we actually need civil rights lawyers. We actually need human rights lawyers, and that we actually need to have some sort of regime that protects people's rights. That's good news, and I think we should not. And also now we have, I think, a movement of people that are very, very concerned. And I think we should reflect on that and consider that a good news. The not so great news is I think that people are starting to get tired. I think there's an exhaustion factor to all of this. Every day, someone's meeting with the president talking about something that's a distraction. Every day, the president is distracting us. Every day, this administration is doing also, on the same time, really horrible things. And I think our allies get tired. I think we get tired. And I think the danger is that we start normalizing this behavior. We start saying things like, well, Brown, yeah, we shouldn't necessarily think that anything's wrong with not saying Brown was rightly decided. And the more you say that, the more it will become, yeah, that's actually okay. That doesn't mean they're necessarily going to. It's not necessarily a dog whistle saying that come to me and I'll take your challenges to any of the Brown legacy issues like LGBT bathroom, the rights to choose a bathroom of the sex of the sex of your choice, or your designation. I mean, I think that all of these things are there's a risk to normalizing. And I think that we need to make sure we don't do that. We need to make sure that we continue the effort and continue to fight, and that we hold those allies accountable for not normalizing. And so I'll end with that. And if there are any questions, I'm happy to take them. And I appreciate your time.